Rescission. Rescission is an equitable remedy whereby a party who, as a result of fraud, false representation, mutual mistake, impossibility of performance, or other cause resulting not from his own wrongs, has entered into a contract, may be relieved of the contract or from the consequences of having already performed. Rescission is a purely equitable remedy, and for relief to be granted, the plaintiff must show the court that he is clearly entitled to the court's assistance. Now, let's go back to mortgage. I like to harp on mortgage because I can damn near destroy 98% of them that exist, all right? Because they really don't exist, all right? They're a fallacy. And to prove my point, Fannie Mac has fictitious mortgage and fictitious loan documents that are required to be filed on record as well. And the bankers never do any of that. Not only that, but in the mortgage documents, they are supposed to give you the Truth in Lending Act, per TILA, T-I-L-A, Truth in Lending Act, Regulation Z. They're supposed to provide you the H-8 and the H-9, which is the rescission documents. They never provide those. They provide instead HUD statements, okay? So they violate the law with the mortgage agreement, all right? Or the mortgage package. So just on that alone, you can destroy a mortgage. Not to mention, there never was a loan. The mortgage is not in arrears. Why is the mortgage not in arrears? Because the note is not due until maturity, 35 to 40 years down the fucking road. So there are no arrearages, first and foremost. And the bank refuses to produce the 1098, which would show that they have a statement of interest on file with the IRS, okay? Elements. A complaint for rescission must be set out the following essential elements. 1. The making of a contract. Evidence of the contract should be attached, if available. 2. Existence of fraud, mutual mistake, false representation, impossibility of performance, or other grounds for rescission or cancellation. 3. Plaintiff has rescinded and notified the other party that he has rescinded. 4. The plaintiff has received any consideration for the contract. He should state his offer to restore the defendant to the extent of those benefits, if restoration is possible. And 5. Plaintiff has no adequate remedy at law, i.e., an award of money damages alone is not sufficient to restore the plaintiff to his status before the fact. If rescission is granted, the court will attempt to restore both parties as nearly as possible to status they enjoyed before entering the contract. This is the goal of rescission. A common cause for rescission results when an elderly person of limited mental ability unwittingly executes a deed selling his home to a person who knew or should have known the incapacity of the seller prevented him from appreciating the consequences of his act. In such cases, the deed will be rescinded, and the buyer will be given back what he has paid. So both parties are restored as nearly as possible. If the buyer, in such a case, was aware of the sharp deal he was making at the other's expense, the court need not go to the trouble of restoring the purchase price. Equity may punish as well as protect. Rescission is sometimes a harsh remedy and is not therefore favored by the courts. Defense. Adequate remedy at law. If plaintiff's damage can be corrected by a money judgment alone, rescission is not the proper remedy, and the court for rescission should be dismissed. Modifications of contract. If the contract has been modified after the fraud or mistake was discovered, the court will not rescind, unless the modification is also the result of fraud or mistake. Specific performance. Specific performance is, in a way, the converse of rescission. Where rescission is an action to avoid the consequences of a contract, specific performance is an action to force an unwilling party to perform his obligations under the contract. Cases arise frequently in land deals where a seller enters a contract to sell, buyer performs all conditions precedent, and seller refuses to close. The elements are quite simple. Elements. 1. Existence of a contract. 2. Plaintiff's performance of all conditions precedent to closing. precedent to closing, 3, defendant's refusal to perform. 4, absence of an adequate remedy at law, i.e. money damages alone, are insufficient. And 5, plaintiff has suffered damages as a direct result. The property need not be land. It could be an extremely unique item of jewelry or an antique painting that cannot be replaced, regardless of money available to purchase a substitute. This is the gist of the specific performance. On the other hand, if the property is not unique, as might be the case with a single plot of large subdivision, where one plot is pretty much like any other, the court may refuse to grant specific performance, since an award of money would allow the plaintiff to purchase another property substantially identical. Spoliation of evidence. Until recently, there was not an available cause of action in itself, though a party was entitled to argue prejudice in prosecuting other claims against parties who destroyed evidence negligently or with invidious intent. Today, in many jurisdictions, a plaintiff who lacks sufficient evidence to bring a case for negligence or breach of contract, for example, because the other party destroyed the evidence, has a separate cause of action for spoliation. After all, what's the point of bringing a lawsuit for negligence or breach of contract if you know from the outset that the evidence you will need to prevail has been destroyed? Now, in many jurisdictions, you can go ahead and sue for damages you might have recovered by stating a cause of action for the spoliation of the evidence. Elements. The essential elements are 1. Existence of a potential lawsuit. 2. Defendant's legal or contractual duty to preserve evidence material to plaintiff's case. 3. Defendant's intentional or negligent destruction of the material evidence. And 4. Significant impairment of the plaintiff's case as a direct result. And 5. Plaintiff's damages. In a recent Florida case, a truck rental company employee suffered injuries when a ladder belonging to the company collapsed. Before the case could be filed against the ladder manufacturer, the truck rental company sent the broken ladder out with the trash, effectively destroying the injured employee's case. So the employee sued the truck rental company for spoliation and won the full value of his injury, medical bills, loss of future earnings, loss of enjoyment of life, etc. It didn't matter that the truck rental company was in no way responsible for the ladder failure. The court found it liable to the employee on the theory that it knew or should have known that the ladder was critical evidence, and its acts of tossing the ladder in the trash was breach of duty, giving rise to a cause of action for spoliation of evidence. Tortious interference. Tortious interference takes two forms, differing only in the elements necessary to plead and prevail. Tortious interference with an advantageous business relationship does not require the existence of a contractual relationship. Mere expectancy that the relationship would have continued but for the interference is sufficient. Indeed, the cause of action will lie even when the business relationship is based on a contract that is void or unforeseeable. Tortious interference with a contractual relationship, like the name implies, results where the plaintiff is injured as a result of the defendant's interference that results in the breach of the plaintiff's contract with another. That's protected by Article 1, Section 10 of the United States Constitution. You have a right to contract without being interfered with by other third-party interveners, including government, all right? Which means you also have the right not to contract. To include one thing is the exclusion of others, and deny one thing is to admit 1,000 others. The elements are similar for both. Elements for tortious interference with an advantageous business relationship. 1. Existence of a favorable business relationship, not necessarily evidenced by contract. 2. Defendant's knowledge of the relationship. 3. Defendant's intentional and unjustified interference with that relationship. And 4. Damages to the plaintiff as a direct result. For tortious interference with a contractual relationship, 1. Existence of a contract. 2. Defendant's knowledge of the contract. 3. Defendant's intentional and unjustified procurement of the contract's breach. And 4. Damages to the plaintiff as a direct result. Discussion. In order for either form of tortious interference to lie, the interference must have been intentional. In most jurisdictions, negligent interference is not a cause of action. Where interference with a business relationship is lawful competition, the cause of action will fail. Where interference involves theft of trade secrets or misappropriation and use of proprietary confidential customer lists and critical information, the plaintiff's entitled to a money judgment to recover the value of the relationship prior to the defendant's interference. Theft of trade secrets or unlawful use of the proprietary client information of another is not lawful competition. A temporary injunction may be obtained in some cases to prevent the interference from continuing. Interference with a contractual relationship is more severe. If plaintiff's contract is enforceable, the defendant's intentional acts interfere with the contract so that the breach or other diminution of value of the contract results. Plaintiff's damages are more easily determined and defendant's wrong more clearly identified. It is not lawful competition to encourage one person to breach his contract with another, and those that do so are liable to the plaintiff who sues for tortious interference with a contractual relationship. When we come back, we're going to be talking about unconscionability. It's also supported by the Bible and a litany of maxims of law. And we'll get back to you with unconscionability.